Welcome to today's program.
Yes.
We have a program from our Constitution and Constitutional Law Secretariat of Bangladesh Law Alliance, and today we will talk on the particular topic. This is relating to the judges' tenure of office in India and Bangladesh. Should it be increased or not? And to talk on that, we have a very special guest today, Mr. Justice KSP Radhakrishnan, former judge, Supreme Court of India. Hello, sir, and
Yeah.
thank you for joining us. Sir, I would like to go straight to the subject that it is a very talkative issue now in Bangladesh and in India. For your kind information, I would like to say about Bangladesh a few words that in 1972, back in the very first constitution, we have 62 years of age for the retirement of judges. We have two divisions in the Supreme Court. One is appellate division and the other is high court division. Both are same in order to retiring from the office, and it increased in other years to 65, and now it is 67 in the higher judiciary of Bangladesh. And in your country, it is 65 in case of Supreme Court, and in case of High Court, it is 62. And many jurists, many former judges, and many other jurists and senior counsels, like in your country, I know you have a particular standing regarding this, but in your country, the Attorney General, current Attorney General, Mr. K.K. Venugopal, and the current President of Supreme Court Bar Association of India, Mr. Vikas Singh, their standing is different from yours, that they actually want that the tenure of office should be increased. So, sir, would you please give your remarks on that?
Shall I start?
Yes, sir. Sure, sir.
Thank you, Mr. Saeed bin Nazar, the President of the Bangladesh Law Alliance. I'm so happy that youngsters like you has organized a program like this. This is how the young minds always should be, so that new ideas and new concepts will emerge. I think I'm glad to see that in Bangladesh, also in India, most of the young lawyers and youngsters organize a lot of programs. That is really good, because in our olden days, when we were in law college and the early times of my judicial career, nobody conducts any seminar or a program like this. So the knowledge was not that much, because of all bookish knowledge, because at that time computer or Google, etc., was not aware. So whatever knowledge we gather, either from elders or some books available. That is not the case nowadays, because the world has changed. Science and technology has changed a lot. As you understand, I understand Bangladesh also, so far as the Supreme Court is concerned, the retirement age is now 67. India still retains its retirement age of 65. Of course, recently also in the Indian Supreme Court, Chief Justice Mr. Ramana has said that retirement age should be increased. And they said that he's young and he can still work for another few years. But I always maintain a different view on this retirement age, especially this part of the world. The retirement age, according to you, is 65 in Indian, which is a stipulated Indian Constitution, is the right age for a judge to retire, because the Constitution makers have thought of the retirement age of judges. It is High Court is 62 and the Supreme Court is 65. The reason behind such a stipulation, to my mind, is that, see, the workload in the Supreme Court, in the High Court, as well as the lower judiciary in India, is so much that a human being it is impossible to cope up with the workload. There may be judges in the High Court as well as even the Supreme Court who take it very lightly. But a conscientious judge, hardworking judge, will not work very hard throughout his life. As you are aware, see, before becoming a judge, see, either you must be a judicial officer or you must be a member of the bar. I was a member of the bar. I put in about 24 years of my as a lawyer. I practiced in various courts in the country. And after with that knowledge and experience of 25 years as a lawyer, I was selected to the High Court. And I was to begin with, I was in the Kerala High Court. It was my parent High Court. Then I became Chief Justice of 2 High Courts. And then ultimately, I was elevated to the Supreme Court of India. But during the course of all, that means almost 20, I was in the higher court, High Court and the Supreme Court put together is about 20 years. That means 25 years of my as a lawyer, another 20 years judge makes 45 years of my work very hard. So unless you prove yourself as a lawyer, you won't be considered as for judgeship. So that is that you neglect your family, public, neglect your friends, neglect your well-wishers. We have not time for anything, only for do your work. Oh, so much of involved in my profession as a lawyer. Of course, slowly I enjoy my work. With the result that I hardly find time even to attend to my household affairs or any other thing. I thought the only word around is only law and court. There's a word, another word is also there. You are forgetting that fact. As a judge also we hear litigations only, dispute between parties only. There is no other job the judge does. His only job is to decide disputes. So you hear every now and then you hear disputes between parties, criminal cases, civil cases, and so many disputes. So forgetting the fact that apart from this dispute, there's another word that you must know what is that word around. So I left myself and I retired at 65 years of hard work. I was very happy. I never regret. I never wanted to be more than 65 years of my after retirement. I never thought of working also. And I find a different word after retirement. So only if you retire, you will find out the beauty of retirement. See, I have got another word. I'm a free man. I can express my opinion on any issue, whether not bordering the contempt of law. On any issue, whether in the Supreme Court or any issue, national issues or international issues or anything, I can speak openly. But so far as judges are concerned, there's a code of conduct. You have to be very confined to that code of conduct. You cannot express an opinion that is pending for court. And as a judicial discipline, we hardly express an opinion, even if the matter is pending before the Supreme Court of Bangladesh or any other court, as a matter of discipline. There's a lot of controversial issues pending before the Pakistan Supreme Court, Bangladesh Supreme Court, and so on. But I'm so happy that many of my judgments have been followed by the Supreme Court of Pakistan, Supreme Court of Bangladesh, especially on transgender issue. So that is the first decision rendered by any court in any country on the rights of transgenders. We have I had at that bench, and that decision recognized the right of transgenders, their difficulty they experienced throughout their life, the way they were marginalized from the society, the way they live in the streets of Bombay, Delhi, and various other cities, because they are even outcast from their houses also, because there's a great human life issue. So that we resolved, and I'm happy that many of the courts have recognized that judgment. And another judgment also I read about the rights of animals, how killing of animals, the pain and suffering suffered by animals. So that is also recognized by all over the world. And now one case is pending for the in the Supreme Court of New York, where I have also intervened on their request. So that matter is pending. So these are many of the issues we work on that. And there are a lot of other issues also we handled throughout the judicial career, doing a lot of research by ourselves as well as with the assistance of young lawyers. But when you discuss the matter with the young lawyers, you find that young minds work differently from old people. the new concept, new ideas, and new vision should come. Because so far elders are concerned, some of the old habits never die. They continue with the old concepts, old ideas, old vision. It's very difficult to sometimes to change it. The changing world, the problem is that nowadays many of the lawyers also you find who argue in the High Court. I find some of the young minds, young lawyers are better than many of the senior lawyers. The reason being that the type of education that they get from various colleges in India and abroad, from UK. Therefore, many of them go to UK or US and various other renowned universities. So they are well equipped to meet many situations. Especially in ever-changing law and technology, science and technology. For example, cryptocurrency. I think many of the judges sitting in the Supreme Court in Bangladesh or in India or in many other neighboring countries, they do not know what is a cryptocurrency. And there are a lot of other technical issues are also emerging now. The traditional type of litigation, property disputes, etc., is gone, or divorce matters, etc., is gone. Now we are on a different path, a different area. So young minds should come and replace the old judges. The problem is that we find that especially on a very technical scientific issue, many of the lawyers are also unaware, barring very young lawyers who are enthusiastic, wanted to study, wanted to know exactly what is the problem. There are many lawyers up there before me also. So they have to first teach the lawyer. A senior lawyer may not be aware. He may have experience, but he don't have the expertise, or he has not studied a new concept on a new scientific, with a scientific basis. He doesn't know on any different accounting, finance, or currency, or anything in any areas. So he has to first teach a senior lawyer. Then senior lawyer has to teach a judge, and judge delivers judgments. Suppose a young judge who is well equipped in these areas, for example, any areas of expertise which requires expertise, new emerging fields of law, he is in the bench, maybe in the lower court, and then to the High Court and the Supreme Court. So he has better experience many times to decide an issue, at least. So if let a judge 65 retire, let youngsters come up. Youngsters with new ideas, new visions. Why should they hang on there till 80 years? Why should they hang on to a post for till your death? For what purpose? Without knowing what is happening all over the world, without noticing technology. For example, take the medical field. See, a very good scientist, doctor, he should be a good engineer also, because many operations are done not by hand. It requires a lot of knowledge of machinery. Some robotic surgery is also there. A very old doctor may not be able to do as a surgery as a young doctor, because comes up with better knowledge on science, on better knowledge of medicine does. You must be knowing that in my experience, I have seen many of them. So, for example, suppose you want to have a surgery. Many of the patients now, they prefer youngsters, younger surgeons, now than a very old surgeon. Because it requires a special skill, special knowledge. Because they have been studying medicine in the medical college. What we have studied 20 years back in a medical college is not what is being done now in the medical college. Just like in law college, what we have studied when we were in law is only in property law or contract law, etc. Now law has changed. Now there are energy law is there, new fields of law is there. So that entire concept has been changed. So why should I always feel? Why should I hang on to a post till your death? You just give place to a new blood, new ideas, new concepts. So that's always in mind. Whenever somebody says that you want to, why should you be in the office? What purpose? And not only that, those judges who retire from the Supreme Court, High Court, are also very much wanted in their field. There are a lot of avenues also, a lot of arbitration matters, a lot of consultations, and there are a lot of other, they can head various commissions. Their knowledge can be utilized there, whatever knowledge they have. And apart from that, there should be a. I just told you that you should have another word. You must know what it is. Yes, Mr.
So
Nasir.
that there are plenty of fields to
Yes.
do work, and in case of it is said that the experience that matters, and you have a very interesting dimension, that experience versus adopting with new generation. And it is true that the new generation should be given the opportunity so that they can also be furnished and they can also build up with their experience by the pace of time. But sir, in case of Supreme Court and High Court, the age is different, as we already discussed. So, do you think that it can be equalized, that 65 High Court judges
But
tenure should be?
that's not a big problem. It's only a matter of 3 years. That's not a big problem at all. That can be done. That can be raised to 65, so that many of them may not go to the Supreme Court. They want to be a Chief Justice or various High Courts rather than the Supreme Court. You may have sometimes more power as a Chief Justice of a High Court rather than the Supreme Court, because a puny judge in the Supreme Court has no administrative work to do. But a Chief Justice of a particular High Court is a better place. Suppose if it is 65, I think many of the Chief Justices may not go to the Supreme Court.
It can be.
It can be equalized, no problem for that. But some of them would like, unless you have got a reasonably good period Supreme Court, you won't be able to contribute yourself. Because first 2 or 3 years you will be with the senior judge of Supreme Court. So he will be heading the bench. Many a times you will also sail along with him. Many of the judges, of course, they may not express the independent views on that. Also, don't we want to antagonize other senior judges? That also happens. So you hardly, after 2 or 3 years, you will be able to head a bench. So many of the Chief Justice High Court may not prefer, if you got a very shorter period of the Supreme Court, to be in the Supreme Court, unless you got a 5 to 6 years, so that you can contribute anything to the system.
So you have a very vast experience from 1973 till now. Somehow you are affiliated with court, not directly in office, first in bar, then in bench, and then now as arbitrator and many other issues. So nearly about 50 years. So if I talk on the issue that contempt of court, which what is your view, sir? Many jurists say that it shouldn't be criminalized anymore. So, sir, what is your view? Would you please give?
I always take a via media. Suppose we say that, see, whatever the judge decides is a law. It is a list between 2 parties. So suppose one party is not obeying the court, the verdict of the court, naturally other party can prepare a contempt petition, because court is only deciding this between 2 parties. So suppose the one party is violating, is not following the judgment of the court, or not following the directions, other side can definitely approach the court for contempt because of non-compliance of the order of the court. That's one side of it. Then criticizing the judges. Criticism always, you can criticize the judgment, no problem at all. You have to criticize, then only law will develop, because these are human beings. Those who are sitting in the Supreme Court also human beings. They may err. Any human being may err. But you shall not err.
About criminalizing the criticized part. And do you think, sir, that shouldn't be criminalized anymore? And we should go for a liberal approach in this regard.
There must be some penalty. Otherwise, problem will be, they will feel that you must give us some respect to an institution. See, you can go on criticizing a judge, he's a human being. You can go on criticizing him personally. See, you won't be able to discharge his functions. Suppose he decide a case today, tomorrow a lot of unnecessary, healthy criticism is always welcome. It should be there. Healthy criticism of the judgment of the judges is always welcome. But if any criticism, personal criticism of judges, that will weaken the system. But judge will not be able to function if he is going, and that is not penalized. So there must be some machinery. Only machinery is the judiciary. There's an independent judiciary, because the parliamentarians or the ministers, they will not take any action because they're not concerned. Sometimes they decide against the ministers also. So system is so independent that whenever you decide an issue, of course, you create an enemy or somebody who are not happy with the judgment. Maybe right or wrong, maybe, but somebody has to decide it. Somebody has to decide it. Yeah.
Sir, we are in the very last page. Sir, what is your view regarding writing judgment after even retirement? Is it happening in India?
No, that you can't write a judgment of retirement. You have to repost that. I won't advocate that. You have to finish your work within the time. Why should you retire and after retirement, authority? After retirement, what is the authority to write a judgment and deliver it? What is the authority? You have no authority. The moment you lay down the office, end of the day, you cannot write a judgment after retirement. Exactly. And if you could not complete your judgment, you must repost that case, so somebody else will hear it.
Sir, one last question, sir. Is it expressly barred in the Constitution of India to appoint someone as judge who has dual citizenship? And yes. What is your view regarding this?
There are few instances also. I think some of the jurists have been considered for a judgeship. It is there. That we hardly invoke that provision.
Sir, is it constitutional? What is your view, sir? For your information, sir, in Bangladesh, there are three certain cases which actually took place. That in certain cases, some people have been appointed as judges of the Supreme Court who holds dual citizenship, but many jurists in Bangladesh, but Bangladesh Constitution directly don't put any bar, but many says that in considering the constitutional state.
I don't think India, I don't remember. I may be correct, I may not be right. I do not know. But I don't think that any jurist has been elevated as judge of the Supreme Court. From the bar, directly from the bar, we have a lot of lawyers who are elevated to the Supreme Court directly from the bar. But they're not a jurist, I think. It's not there.
Sir, but in Bangladesh, many opine that it is not constitutional to appoint someone who has dual citizenship. Sir, what is your view regarding this?
Dual citizenship.
Exactly.
I think the Indian Constitution should be a citizen. Should be a citizen. The dual, I won't advocate for a dual citizenship to be a judge. Should be a citizen. You can be born elsewhere, no problem. You can be born in Africa or various other countries. You may have born outside. But once you get a citizenship of Bangladesh or a citizenship of India, then you can be considered as a judge of the Supreme Court or High Court or the lower judiciary.
Sir, a person who holds citizenship of two countries, the holder of that dual citizens, should they be appointed as judges of the Supreme Court?
Personally, my view, you should surrender that citizenship. If you are a judge of a particular country, you must be a citizen of that country. You cannot have both. You cannot have a lead.
Citizen of that country as well, but a citizen of UK or some other country.
No, my point is you cannot have allegiance to the two constitutions. There are two countries. If you want to be a judge, you must be allegiance only to the country where you are a judge. Otherwise, there must be some difficulty. Sometimes the constitution of your country in which you have citizenship may have a different view on certain aspects, but they will be violating the constitution of that country. Obviously, as you are a citizen.
Exactly, sir. There is a constitutional dilemma, and this is a most vital point that many made, that that shouldn't happen. So thank you very much, sir, for your
Thank you,
very
sir.
wonderful and
You,
very important.
the pleasure to talk to an youngster.
Sir.
It's a pleasure to talk to an youngster like you.
Sir, thank you very much, sir. Thank you very much.
Take care. My regards to all your colleagues.
Exactly, sir. Thank you very much, sir. Hopefully, we'll join in some other sessions, sir. Thank you very much.
Thank you. Thank you.